in numbers, Saraki in the eyes of the court. In 4 years, here is how Senate President Bukola Saraki has visited the court and why. In charge number ABT/01/15, dated September 11, 2015 and filed before the Code of Conduct Tribunal, CCT, Senator Bukola Saraki was accused of offenses ranging from anticipatory declaration of assets to making a false declaration of assets in his assets declaration forms. He was also accused of failing to declare some assets he acquired while in office as governor of Kwara State, acquiring assets beyond his legitimate earnings, and operating foreign accounts while being a public officer. An official of the Code of Conduct Bureau, Peter Donladi, stated in an affidavit in support of the charge that the investigation of the various petitions of corruption, theft, money laundering, among others, against Saraki in 2010, was conducted jointly by the officials of the Economic and Financial Crimes Commission, EFCC, CCB and Department of State Service, DSS. Saraki became the first Senate president in Nigeria to be issued with arrest warrants, after chairman of the Code of Conduct Tribunal, Donladi Umar Dule signed the arrest warrant against Saraki on September 18, 2015. After months of media roar against the federal government over his ordeal at the CCT, Chief Kanu Agabi, San, Saraki's lead counsel and ex-attorney general of the Federation, led a team of 79 lawyers to defend Saraki at the tribunal. While the CCT trial was ongoing, the EFCC on April 1, 2017, released a report which indicted Saraki and some of his aides in the alleged laundering of up to $3.5 billion from the Paris Club loan refund. The EFCC investigation was presented to President Muhammadu Buhari in a report delivered on 10 March. 5 days before the Senate rejected acting EFCC Chairman, Ibrahim Magu. However, in a swift reaction, Special Advisor on Media and Publicity to Saraki, Yusuf Olaniyi, in a statement denied the claims. Saraki was never charged with any crime relating to the indictment. On June 14, 2017, the CCT, sitting in Abuja, discharged and acquitted Saraki, in the 18-count charge of corruption, false declaration of assets charge brought against him by the federal government. The tribunal held that the evidence adduced against Saraki by the federal government was bereft of probate value and manifestly unreliable to hold the charges against the defendant. The chairman of the tribunal, Donladi Umar, said the prosecution at the close of the case failed to establish a prima facie case against the defendant. Umar said the 4 witnesses called by the prosecution to testify in the matter gave contradictory evidence that was manifestly unreliable to convict the defendant or order him to enter his defense. The federal government, however, appealed the CCT judgment. Delivering judgment on the appeal filed against Saraki's acquittal by the federal government, the Court of Appeal on December 12, 2017, ordered the tribunal to try Saraki on 3 out of the 18 counts amended charges bordering on false declaration of assets brought against him. The appeal court also held that the prosecution failed to adduce evidence to substantiate the 15 of the counts preferred against Saraki. Not satisfied with the appellate court decision, Saraki approached the Supreme Court for intervention. On July 6, 2018, the Supreme Court dismissed all 18 charges of corruption and false asset declaration brought against Saraki. A 5-member panel of the Supreme Court, led by Justice Atijo Muhammad, held that the decision of the appeal court to agree with the tribunal in one breath and order Mr. Saraki's return to the CCT in another amounted to a judicial somersault. The justices in a decision read by Justice Sentencins held that the prosecution was duty-bound to produce a witness with direct links to the evidence. They said the failure of the prosecution to produce such a witness rendered its case defective. Justice N said it was ironical for the appeal court to submit that the prosecution failed to bring those with direct knowledge of the evidence and still proceed to rule that some of the charges were meritorious from the same set of pieces of evidence already declared as hearsay. This court will not lend its jurisdiction to such a charade and caricature of justice, the Supreme Court ruled, describing the decision of the appeal court as a grave error. An advocacy group, Legal Defense and Assistance Project, LEDAP, on September 14, 2018 filed a suit before a federal high court sitting in Abuja seeking to declare the seat of Saraki and 55 other lawmakers vacant following their decisions to defect it to other political parties before the expiration of their tenure. The group, in the suit, prayed the court for an interpretation of Section 68(1)(g) of the 1999 Constitution with regards as to whether any member of the National Assembly, who resigns from the political party that sponsored his election before the expiration of the term for which he was elected, automatically loses his seat in the Assembly. The group is also seeking a declaration that the lawmakers were no longer entitled to receive any remuneration due to a member of the National Assembly and that any of such remuneration after their date of defection be refunded to the federal government. The suit had proceeded unchallenged until Saraki and other defendants approached the court after judgment date had been fixed. Trial judge has, however, adjourned the matter to allow Saraki and others present their case.